Sir, in addition to being a member of this August House, I'm also the Vice Chairman of the Amar Raja Group. We manufacture the Amaron brand of automotive and industrial batteries. We've been in the business for 30 years now. All our factories are in Chittoor district of Andhra Pradesh, where we employ more than 16,000 people, all in non-migratory jobs. 90% are from the local district, and 80% are the first job in the history of their families. So these are my credentials to be speaking on this subject, sir. And since we are combining three bills together, which all are very important.
Your credentials are already very rich.
Yes, sir.
No,
so
please.
I request that I may be provided some extra time so that I can get all the points across to the minister, sir. Sir, there's no doubt that this is a humongous exercise because it is not child's play to bring nearly 45 enactments together and guide more than 100 other enactments being implemented by various states. So without any hesitation, I compliment the Honorable Labour Minister, Sri Santosh Gangwarji, for his stupendous work on these codes. Sir, I'll start with the Social Security Code. Sir, relating to the methodology of computation of PF and insurance contribution under Clause 78, I suggest that these be calculated on basic wages and not to include commission or performance-based bonus, business expenses, leave encashment, etc. So they may be removed from the definition of wages, sir. It will help employees in taking more salary home, sir. Sir, Clause 2, bracket 88, definition of wages is inconsistent compared to our present definition of wages under various labor laws. This may lead to further liability to the employers when calculated under different benefits. For example, definition of wages under gratuity has been widened and has increased the gratuity liability of employers, sir. Sir, Clause 45 on unorganized workers. The bill allows schemes for unorganized workers to be additionally funded by the Corporate Social Responsibility Fund defined under the Companies Act 2013. However, the bill does not include provision on overriding effect of more beneficial welfare schemes already passed by different states. So this could kindly be looked into, sir. Sir, Clause 142 on the application of Aadhaar. The code is making Aadhaar mandatory to receive benefits. My question is this not a violation to the prevailing Supreme Court judgment, sir? Sir, the code is also silent on international workers. There is no definition for international worker. So employer who engages international workers do not know how to calculate the PF contribution, etc., to be made. There is clarification needed on this also, sir. Now I'll come to the Industrial Relations Code, sir. Sir, I welcome the proposal of a predefined fixed-term employment under Clause 2, bracket O. The concept of this is based on the need for industry to hire for projects or seasonal requirements like road, infrastructure projects, and international orders. Presently, what the companies are doing, they hire a contractor, and the contractor in turn engages the workers. But the point is, whatever company pays to contractor in the name of a worker is not reaching the worker, due to which workers lose out on the money entitled to them. They are also denied Social Security benefit. So the fixed-term employment would address this problem. While we welcome fixed-term employment, we also foresee a danger of companies avoiding permanent employment, so it is good to add a minimum and maximum tenure for fixed-term employment also, sir. Sir, Clause 83 of the bill deals with the reskilling fund. It is a new provision in the code, and I welcome this. The code says that the reskilling fund needs to be created with the government, and employer will pay 15 days of wages to the fund within 45 days of retrenchment. But I submit for consideration of the Honourable Minister to exempt such establishments which are on the verge of layoffs or closures. Otherwise, this will be an additional burden on them, sir. Sir, secondly, we have a huge Ministry of Skill Development, so the ministry should also make its contribution, financially and otherwise, to make this reskilling a success, sir. Clause 2, bracket 2F, concerted casual leave on a given day for 50% or more workmen would be treated as strike. This is welcome and in many ways prevents unnecessary industrial unrest. We also need to be cautious that we do not infringe on the rights of the workers, sir. Clause 44, bracket 2, the code introduces industrial tribunal consisting of two persons and one from judicial and the other from administration, instead of one person in the earlier Industrial Dispute Act 1947. Though this is a good move, it would be prudent to make the number of members in the tribunal at an odd figure instead of an even one, so as to settle the case if there was difference of opinion between the members, sir. Sir, clause 62, bracket 1, the code introducing 14 days notice to be given for strike is good as it gives time for discussion and dialogue. This should be uniformly applied for all sectors, sir. Sir, clause 2, bracket ZC, the code drops the termination of the service of a workman on the ground of continued ill health from exclusion of retrenchment. Retrenchment arises out of business continuity challenges and hence should be applied evenly to all as required, with no exceptions, as the prevailing Industrial Dispute Act. Clause 53, bracket 1, the code provides that the conciliation officer shall not hold any such proceedings relating to the industrial dispute after 3 years from the date on which industrial dispute arose. We appeal that the time given is too long and should be reduced to 6 months. As part of ease of doing business, should we have not done away with this provision under the IR code, is my question, sir. Sir, under clause 30, the bill proposes certification as necessary, even if the standing orders of an establishment is in line with the model standing orders. If the establishment is pleased to conform with the model standing orders, there should be no certification process and the model should be made applicable automatically, sir. Sir, now I come to the Occupational Safety, Health and Working Conditions Code, and I'll just complete in a few, 2 minutes, sir. Sir, the first point I wish to make is relating to the provisions on welfare, such as canteen, restrooms, and appointing welfare officer. The proposed code reduces the manpower applicability when compared to the Factories Act. You have brought it down to 100 workers against 250 as per Factory Act for the canteen workers, 50 against 150 for restrooms, and 250 against 500 for appointing a welfare officer. But I would suggest for the consideration of the Honourable Minister to retain the provisions as mentioned in the existing Factories Act. Otherwise, this would impact the MSMEs the most, and this additional burden, when they're already suffering, the MSMEs in the condition they are today, this would be an additional burden on them. So you could think of exempting the MSMEs, sir. Sir, clause 27 of the code deals with extra wages for overtime, and calculation of overtime is mandated on a daily basis or weekly basis. And secondly, about the written consent for overtime. Sir, it is very difficult to calculate overtime on a daily or weekly basis. There is a wastage of valuable time. So I suggest that this could be made monthly and could be paid out monthly also.
Please.
And getting written consent every time is also difficult. I'll finish in 1 minute, sir. And getting the written consent is also very difficult. The consent of the worker can be taken at the time of appointment itself. If he does not want to work overtime, he need not give his consent. Further, the worker can also be provided the right to exercise inability in any given time during the employment for genuine reasons. Sir, in clause 87, where it talks about penalties, prosecution of employer should be removed from Occupation Safety Act. Penal fines should be a sufficient deterrent. Prosecution, however, can be considered in the worst cases where there has been a fatal accident or if the employee is adversely hurt due to negligence of the employer. So, sir, these are some of the submissions that I wish to make for consideration of the Honourable Minister, and I expect him to please act on them positively. With these observations, I support the codes. Thank you, sir. Thank you, sir.